I will try to point out the main points where the National Green Tribunal has made a significant impact and what are the impediments to a properly functioning National Green Tribunal, because that's a civil society challenge. Why is National Green Tribunal very important? I think it's the issue that comes up. I'll try, but my problem is I can go at one language in one go, but to make the change. But is why it is very important? Why a tribunal? And I think that's very important question. Tribunal and court in a traditional, whether it's a high court or a supreme court, usually, when two people are fighting, even if we see activists fighting with industry, they will say, I will drag you to court. Court kacheri mein leke jaunga. Koi nahi bolta main tumhe tribunal leke jaunga. So the general idea is that tribunal may be a weaker place to go than to a court. And I think that's, to some extent wrong for one reason. And one of the very important part of that is that many of the time when we do actually public interest litigation or a 32 or 226 petition, we actually do what is called a judicial review, a lot of it. And in judicial review, the courts have been very clear. There have been exceptions here and there, but generally the court has said that we will look into the decision-making process and not the decision. So, if on merit the decision is right or wrong, if the process has been followed, we will not come in and into the picture. So, EI report has been prepared, public hearing हो चुका है, उसके बाद एक्सपर्ट अप्रेजल कमेटी के सामने मैटर गया है और प्रोजेक्ट क्लियर हो गया है. अगर वो प्रोसेस ठीक तरह से हुआ है, द कोर्ट विल नॉट से कि यहाँ पर 300 मेगावाट डैम के जगह आप 200 मेगावाट बनाइए, इसके लिए कोर्ट नहीं है. बट कोर्ट्स ने 3-4 डिसीजंस जो वेरी क्लियर है, कहा कि ये जो लिमिटेशन है, दिट इज नॉर्मली एप्लीकेबल टू द हाई कोर्ट्स एंड सुप्रीम कोर्ट्स, इट इज नॉट एप्लीकेबल टू ट्राइब्यूनल्स, बिकॉज ट्राइब्यूनल्स टेक्निकली आर एक्सपर्ट अबव एक्सपर्ट्स. They are judicial and technical members, and therefore they can look into the merits of a decision. And therefore, tribunal के सामने हम केवल प्रोसेस की बात लेके नहीं जा सकते. प्रोसेस लेके जा सकते हैं, कोई प्रॉब्लम नहीं है. बट प्रोसेस के अलावा अगर हम कह सकते हैं कि इस जगह में बिना क्यूमुलेटिव इंपैक्ट असेसमेंट के आप इतने सारे जो है थर्मल पावर नहीं लगा सकते हैं, और अगर लगाएंगे तो EIA रिपोर्ट्स में ये सब 4-5 और स्टडीज होना चाहिए. The tribunal can direct for it. And in fact, the second very important decision of the National Green Tribunal, just to share with you, was directing in the case of the Koradi thermal power plant. I will, जब मैं आगे बढ़ता हूँ कुछ decisions को लेके जाता हूँ कि number one, something which had failed, and I can tell you very confidently कि बहुत सारे PIL फाइल हुए थे across High Court, Supreme Court on thermal power plant which raised the issue of radiation. It was only the NGT which in the first 1 month of its hearing stated that radiation impacts in thermal power plant is a very serious issue, and we hereby direct that in future every terms of reference for thermal power plant must have radiation impact assessments. So therefore that part of it became, because the tribunal has the capacity, the authority to direct the ministry to do what it is. So we have to understand this important power that we can bring in issues with respect to not just the legal violation, but what is not even proper and what needs to be done. So the National Green Tribunal, as it exists, the jurisdiction is very interesting. 2 important jurisdictions with it. Number 1 is the appellate jurisdiction. यानी कि any order passed by the government granting environment clearance, forest clearance, or order or decisions with regard to any of it, or certain provisions of the Air Act, Water Act, Biological Diversity Act, and EIA, against that 90 days के अंदर आप appeal file कर सकते हैं, and that is very significant. We happen to be on the positive side, one of the very few countries where every citizen of India has the right to file a statutory appeal as the first appeal before a tribunal challenging a project. The question that next comes in, who can file an appeal? That's again very important. The NGT, the National Green Tribunal Act, states that only an aggrieved person can file an appeal. So the law says that only an aggrieved person can file an appeal. When we challenged the environment clearance given to Vishnugar people Koti, the 2 of the appellants in the case, one was Vimal Bhai and second was Bharat Junjunwala. Both of them, they did not live in the area. ना तो उस एरिया में रहते थे और ना वो डायरेक्टली अफेक्टेड हैं थे. मैटर गया जस्टिस रामलू के पास of the National Green Tribunal, and we put forward our argument, and the judgment is now clear. It has not been challenged. The Vishnugarh People Court judgment of Justice Ramalu says very clear that the National Green Tribunal Act of 2010 has been enacted by Parliament, and it is a statutory law. And being a statutory law, it has said that only an aggrieved person can come whenever there is any substantial questions relating to environment, or the person is aggrieved by the grant of clearance. What the court, and I think it was a very landmark judgment of the Green Tribunal, it says a statutory law is always subordinate to the Constitution. The Constitution under Article 51AG provides that it shall be the fundamental duty of every citizen to protect nature and environment. Once it is a fundamental duty to protect nature, no law can say that you will be only challenging it if you are personally affected. Therefore, every citizen, the judgment says, has the right to oppose and challenge every single dam, thermal power plant and any other project that comes up in any area. So therefore, the scope of the Green Tribunal is enormous today. And that has happened again by the positive interpretation given by the National Green Tribunal. So this is what I am saying is the appellate. So any order passed granting environment, forest and other clearance today is appealable. आप appeal file कर सकते हैं 90 दिन का अंदर, ideally 30 दिन का अंदर आप फाइल कर सकते हैं, पर 90 पर वो भी कभी कभार होता था पहले में कि आप 30 दिन क्रॉस कर गए तो आप फाइल कर सकते हैं नहीं. Appellate authority ग्रीन ट्राइब्यूनल का जजमेंट है कि this is an environmental court, हम इस मैटर को liberally constitute करेंगे. जब तक आप 90 दिन के अंदर आए from the date of communication, this court will entertain the petition. So there has been a very significant development so far as limitation, that is the time to file and who can file. The second important part जो है Green Tribunal का, that is also very interesting, that is the original power. Original का मतलब है कि even if there is no order passed, there is no order passed granting environment and forest clearance, but जो points which is given there is number one, it raises a substantial questions relating to environment which affects the community at large. So any substantial questions relating to environment which affects the community at large, in which the impact on the ecology and communities are broadly measurable. Now this is a very important part. Broadly measurable, the gravity of damage is substantial and it relates to a non-point source of pollution, that is a subsidiary one. But the main is gravity of damage is substantial and gravity to damage of human health is also of a certain degree, then the tribunal may grant reliefs. Now this is a very interesting part. Under this, if the damage is there and if it is a substantial and broadly measurable, the tribunal can grant relief. And what are the kind of relief? Number one, it can stop the project. Number two, it can, and this is one of the few law in the world where the word is given very interesting. It is that while passing a judgment, the tribunal will be bound and shall apply the principles of sustainable development, precautionary principle, polluter pay principle and the principle of no fault. That means अगर आप fault में भी नहीं है, but you have caused the damage, you are liable to pay for it. So under that, restoration of the ecology, compensation for the loss of livelihood, including crops, fields, fisheries, any loss to the livelihood is now payable as compensation by the National Green Tribunal through an award. Now this part of it did not exist in any law which was there. It was very, very interesting part. You can always go to the High Court and others under the public or the district courts under the Public Liability Insurance Act, but it is today there in the Green Tribunal as a statutory law. And what is very important here is that from 4th of July, as Kanchi was mentioning, when the Green Tribunal started, first 1 week was about 4 to 5 cases a week. Then it increased, and today the National Green Tribunal roughly hears about 8 to 10 cases per day. Now if you look at the 8 to 10 cases per day, in the 8 to 10 cases, almost 90 or I would say 100% of the cases are essentially appeals. There is not a single, only one case that has been filed seeking compensation and damages. Other than that, जितने भी cases filed हुए वो केवल appeal है against the grant of environment clearance or forest clearance. So therefore, there is a responsibility of the civil society to take on these issues of larger compensation and all before the Green Tribunal, because the first question that the judge normally asks is, you want this mine to be stopped, ये mine को आप रोकने चाहते हैं, ये thermal power को रोकने चाहते हैं, पर आप पहले दिखाइए ना कहाँ डैमेज हुआ है, कहीं पर कम्युनिटी आया है उस डैमेज को क्लेम करने के लिए कि हमारे जल के स्रोत सूख गए हैं, हमारे यहाँ पर नुकसान ये इस तरह का हुआ है, तो जब तक वो प्रूफ आता नहीं, I am not saying that an answer, but even if community claims damage to even 1000, that is an acceptance that there has been a violation. The courts in another judgment has also said, the Green Tribunal, that even if there is no violation of law, and if there is 100% compliance of all the clearance condition, but the gravity of damage is measurable, we will still intervene and pass order. Because ministries, we are very well aware, the clearance condition, I think the issue with the Ministry of Environment is not that the EI is a cut and paste. The sad part is the ESC minutes are a cut and paste. The letters granting environment clearance is a cut and paste. Right? If that is so, you can't expect much from there. So the issue is what it has happened. But also, very important is, and I can share with you just few of the interesting cases and issues there. But before that, what are the challenges? And I think that is very, very important also to understand as it. What's the challenges for the National Green Tribunal? In terms of it, Green Tribunal should have 10 judges and 10 experts. Every hearing there has to be an expert member and there has to be a judicial member. Last 1 month, I have been actually moving around along with them to inaugurate, and Neeraj is also here. Yesterday was the launch of the Chennai bench of the National Green Tribunal, that is 24th. On the 10th of this March, the Kolkata bench of the Green Tribunal was also launched, and on 17th, the Pune, and the Bhopal was already set up in December. So what we have is, technically all the benches of the National Green Tribunal has been functional. Despite the greatest force behind not setting up the Green Tribunal, incidentally, is the same ministry which has actually passed the law, or actually ensured that the law is passed, that is the Ministry of Environment. And I think it's a sad one that these decisions that I will refer to have come about despite an active attempt, and I say that with some level of authority, by the ministry to ensure that the National Green Tribunal is not made functional. And what can be the better instance? It's a very sad state. When we go for the hearing, जब हम hearing में जाते हैं, at times, and I think there are people who have heard it, the judge says, we are willing to do it, but please provide us accommodation. We have no house to stay. The salary of the Green Tribunal judges is the lowest compared to all other. 80,000 is what the Green Tribunal judges get. Election Information Commissioner gets more than that, 90,000. The Oil and Natural Gas Regulatory Board and Tribunal judges, or the members of them, get 3.5 lakh rupees. So what has happened is, firstly, create every single hurdle to make the Green Tribunal not function. And today we have a very sad situation where the Green Tribunal actually operates from a guest house of the Ministry of Environment, where the courtroom is below and the judges stay one room above. And that is the status on which it operates, with a great amount of effort being made not to. But despite that, I think certain important decisions have come. They have directed for cumulative impact assessment in one of Nikhil Nair's case for mining which is coming up in Savanwadi. They have asked for radiation impact assessment to be done. They have suspended the environmental clearance with regard to the Scania one, purely on the ground that public hearing was not conducted. They have, in the last 1 week, suspended environmental clearances or state forest clearance and environment for at least 8 projects in the country. That has never happened, combined together of all the high courts that exist in the country. So there has been great amount of thing. A fully functional website 24/7 operates, and I think the word 24/7 is very interesting, because the Ministry of Environment does not have a 24/7 website. If some of you may be aware, and it is now in the decision of the Central Information Commission, that after 5:30 the ministry actually shuts its website. They have admitted that after 5:30 we close it, and every holiday we ensure that it does not open. So the website of the ministry of the Green Tribunal operates, and I think many issues with respect to what was being discussed in the morning are before the tribunal. For example, the issue of fixing criminal liability of EI consultant. That is an issue which was flagged in one of the cases, the Tiroda Gram Panchayat case. And what was very interesting, just to, I'll take another 5 minutes, is a share with you what happened with respect to the case because it's very interesting. The case was concerning our solid waste. Dharmesh is here and who was leading the fight on this particular project. Is our solid waste landfill treatment facility or solid waste treatment facility. The EIA, the environment clearance, was challenged before the National Appellate Authority and it was transferred to the National Green Tribunal. When it got transferred to the National Green Tribunal, the main issue that came in is that can the project be treated as category A or category B? Category A के लिए center will clear it and category B the State Environment Impact Assessment Authority. The issue of contention was that there is a national park within a distance of 10 kilometers. That is the Gindi National Park. This is the Palikarnai wetlands. The interesting issue is that the EIA has been done. Now today we were looking at what has happened maybe in the last 10 years. I am giving an instance which happened yesterday. The EIA was done by a group called ABC Enviro Solutions Private Limited. Now ABC Enviro Solutions Private Limited did the environment impact assessment for it, which happens to be, and very importantly, which they proudly claim in the website, is the first firm to have been accredited by NABET and QCI. Right? So the National Accreditation Board and the QCI can list me if you go, and I think Kanchi has seen it herself. The first name is ABC Enviro Solutions Private Limited by the Quality Council of India. Now this EIA consultant does something very interesting. They say there is no national park and sanctuary within a distance of 10 kilometers. The nearest national park and sanctuary is within a distance of 5 kilometers. They declare in the 150-200 page EIA where the word Gindi National Park is, they mention the word Children's Park. And then to add to that, when the case is filed, they said we calculated it from the project site to the entry gate of the national park through the road distance. And yesterday it did come up in the court's order that it is a very fit case that dust pollution travel by road. And the most interesting part is the judge says that now the ministry and all, you should at least draw up a road map to abate pollution because that is excessive. But till the end, neither the consultant gave up nor the project proponent or the commissioner. On affidavit they have still maintained, despite the forest department on affidavit saying there is 5 kilometers. Unfortunately, with all the discussions that we had, there is no process today to punish directly under the Environment Protection Act. We may initiate criminal proceeding by using the IPC in the district courts, but not in the tribunal, not in other courts, because the liability part is very limited. And here is a problem that needs to be taken up, that here is a EIA consultant, #1 ranked, first firm to have been accredited in India, which declares the national park as a children's park, and at 7 different points mentions that there is no national park, and yet all that happens is the project clearance is set aside. Yes, the project clearance goes, but then nothing stops them from correcting that error and coming back to the ministry by treating it as a category A. I don't agree with all respect, that there is 99.99% approval. There is actually 100% approval, because even those which are rejected do come back after 2 months for reconsideration. Those which have been rejected are only cases where the proponents have not come before the ESC because they have decided to invest the money in somewhere else, and that's the problem that happens. So therefore the liability part, so far as these issues are concerned, becomes very, very critical, and unfortunately neither the ministry is responsible, and I think these are challenges which the Green Tribunal will have to deal. And I think it's an interesting forum. Just to conclude, it's an important step and it can be made use by every one of us, and I think that's the beauty of the tribunal. And I think all those who have gone to the tribunal, many of us are here in the room, will say one thing: we have got good judges now presently, with all respect. There's a good amount of hearing. Every citizen can, even without not trying to get any business out of it, but can appear before the tribunal and argue their own case. And it's very important that, if we are saying environmental damages are done, we should be able to calculate the damage and go before the tribunal and say this is how we are quantifying damages. Unfortunately, in about 6 to 5 months that I worked, we are still not being able to decide how do we compensate or calculate that amount, because for the first time we'll have a forum which is not going to decide an issue only on the basis of the law but also the process. So just to conclude, I can just say that since it started operation, power plant Mundra in Gujarat directed that they should not start work till they get all the other clearances. In case of Scania Steel, which was Ramesh Agarwal's case, they have directed that the environmental clearance is suspended because no public hearing was held. And unless a public hearing is held and the EIA done again, the project is out. In case of Tiroda, they have set aside the clearance, and yesterday in case of Palikarnai, they have also set aside the clearance grant. So we have roughly in the last 1 month about close to 1 to 2 clearances been set aside. That is nothing compared to about 20 to 30 clearances which are granted each day by the Ministry of Environment. But the precedence and the judicial precedent that it may create is very important. I think one at the very end, I'll say, I think there's a symbolic one, and I think those who have been there, there's a very interesting process that goes in the trial. And I think it's a psychological one. The first, hearing when it happened, we had the judges who were not really aware of environment. One extension of that. And within 1 month, the ministry officials used to be there with the lawyer. And within, I would say, 4 weeks of the hearing, the judges made a comment, not obviously in the judgment, which made me realize that at least we have put across our point. That was when the ministry's lawyer says our expert appraisal committee has gone in depth into all the issues and therefore granted clearance, and the judge says, after 1 month we are fully convinced that your expert appraisal committee is neither does it have any expert, nor there is any appraisal, but there is a committee to collect GA and TA. And that is what we are doing so far as environmental governance is concerned. That's what it is.